Deputy Public Defender Oscar B. Rowe here. Dr. Fields has asked me to provide the class with a lesson on the mistake of fact defense to criminal liability. Let's start with the California jury instructions in Cal Crim 3406, mistake of fact. They state, the defendant is not guilty of the crime if he or she did not have the intent or mental state required to commit the crime because he, she, reasonably did not know a fact or reasonably and mistakenly believed a fact. If the defendant's conduct would have been lawful under the facts, as he or she reasonably believed them to be, he, she did not commit the crime charged. If you find that the defendant actually believed the alleged mistaken facts, and if you find that belief was reasonable, he, she did not have the specific intent or mental state required for the crime. If you have a reasonable doubt about whether the defendant had the specific intent or mental state required for the crime charged, you must find him or her not guilty of that crime, those crimes. The court must instruct on a defense when the defendant requests it. There is substantial evidence supporting the defense, and the instruction is legally correct. People v. Anderson 2011, People v. Speck 2022. There is no sua sponte duty, court taking action without a prior request or motion from either party in a case, to instruct on mistake of fact defense. The mistake of fact instruction must negate an element of the crime, People v. Speck. When the court concludes that the defense is supported by substantial evidence and is inconsistent with the defendant's theory of the case, however, it should ascertain whether defendant wishes instruction on this alternate theory. People v. Gonzalez 1999. Substantial evidence means evidence of a defense, which, if believed, would be sufficient for a reasonable jury to find a reasonable doubt as to the defendant's guilt. People v. Salas 2006. If the defendant is charged with a general intent crime, the trial court must instruct that defendant's belief be both actual and reasonable. Mistake of fact is not a defense to the following crimes. Involuntary manslaughter, when the mistake of fact is whether the gun could be fired. Furnishing cannabis or selling narcotics to a minor. Aggravated kidnapping of a child under the age of 14. Unlawful sexual intercourse or oral copulation by a person 21 or older with a minor under the age of 16. Lewd and lascivious conduct with a child under the age of 14. A mistake of fact defense can be based on involuntary intoxication. People v. Scott, 1983. In Scott, the court held that the defendant was entitled to an instruction on mistake of fact, as a matter of law, where the evidence established that he unknowingly and involuntarily ingested a hallucinogen. As a result, he acted under the delusion that he was a secret agent in a situation where it was necessary to steal vehicles in order to save his own life, and possibly that of the president. The court held that although defendant's mistake of fact was irrational, it was reasonable because of his delusional state, and had the mistaken facts been true, his actions would have been justified under the doctrine of necessity. The court also stated that mistake of fact would not have been available if defendant's mental state had been caused by voluntary intoxication. People v. Kelly, 1973. Mistake of fact based on voluntary intoxication is not a defense to a general intent crime. Mistake of fact is not a defense to general criminal intent if the mistake is based on mental disease. People v. Gutierrez, 1986. In Gutierrez, the defendant was charged with inflicting cruel injury on a child, a general intent crime, because she beat her own children under the delusion that they were evil birds she had to kill. The defendant's abnormal mental state was caused in part by mental illness. The court concluded that evidence of her mental illness was properly excluded at trial, because mental illness could not form the basis of her mistake of fact defense. So mistake of fact can be a defense to a crime if you act under an honest and reasonable belief. This does not mean ignorance of the law, meaning that you didn't know you were not allowed to do something, and therefore you had a mistake of fact. An example of mistake of fact is, let's say you're at a bar late at night and set your iPhone down on the bar. When you go to leave, you take what you honestly believe is your iPhone and leave. You drive home, go inside, and suddenly there is a knock on the door. It's the police, and they say that the owner of an iPhone has tracked their phone to your house. You go retrieve the phone and realize you picked up the wrong phone. It is one of the most common phones in the world, and many of them look similar. You had an honest and reasonable belief that you had picked up your own phone. If the police didn't believe you and you were arrested for grand theft, iPhones are expensive. You could claim the defense of mistake of fact. You never intended to deprive the owner of it permanently or to remove it from the owner's possession for so extended a period of time, which are essential elements of the crime of theft. I'm Deputy Public Defender Oscar B. Rowe, and that is your lesson on using mistake of fact as a defense to criminal activity. Thanks for listening, and hope you are enjoying this class.